Well, good afternoon, everyone. My name's Paul Wieck. I want to thank Christy and Dwight for the opportunity to speak with all of you today regarding succession planning for your law practice in Iowa. We know that by far the majority of you have already completed the basic first-tier succession planning duties prescribed by Iowa Court Rule 39.18. So as the event title implies, what we want to do today is go beyond the basic first tier succession planning that you've already done and explore two things. First, how you might increase the effectiveness of your first tier planning. And second, why the second tier option under the rule may have value for you and how to go about that. So with that set of goals in mind, slide 2 breaks down the topics that I'd like to explore with you today. First, I want to mention the Bar Association project that resulted in the new succession planning guide. Then we'll review the first term planning requirement and how you might make it more effective. Then we'll go ahead and explore the value and the mechanics of second tier planning. And we'll finish up with some ideas on what you might want to do and check at this time in your practice. And I believe we'll have probably plenty of time at the end for Q&A. So don't be bashful about sending your questions in for us to work on later in the hour. Slide 3. Last year, the Board of Governors approved formation of a special ad hoc project to develop and publish materials regarding the end of law practice. The new succession planning guide is the first part of that effort. We also have just finished up work on the second guide, which addresses closing a practice. That particular guide is based on a similar document originally published in Nebraska. The Nebraska Bar was kind enough to give us approval to adapt their guide for Iowa in any way we wanted, and so that is what we did. Now, both of those guides are intended primarily for sole practitioners, but we think that firms with multiple attorneys also may find some value in those as they consider what to do with their law firm organizational documents. So the succession planning guide is available for download on the Iowa Bar website on the member benefits page under the heading of practice tools. So you can always find, I think, an up-to-date copy of that at that webpage. So let's talk a little bit about the succession planning guide and its value. What we tried to do with that guide is provide a more hands-on focus regarding succession planning under Rule 39.18 as compared to the CLE outlines that we've prepared and you likely have seen in the past. First of all, we reduced the amount of pure narrative regarding the rule because our sense is you don't need that as much now. What we did was to put more content in the checklist, which we now are calling annotated checklists to reflect the discussion and the practice ideas captured under most of the checklist items. Personally, I think that is where some of the real value of this guide exists, and we're going to talk about those a little bit during the hour here. Now, the planning guide retains the forms developed by the Iowa Association of Estates and Trust Counsel for the Bar Association's first major CLE presentation on this topic that was done in 2017. And we're going to explore those forms to some extent as we proceed. Okay. I'm now at slide 5. I just want to mention briefly a few highlights of the guide. Appendix A, page 12. That's the annotated checklist for a sole practitioner planning for his or her death or disability. And that checklist is divided into actions associated with the mandatory first tier duties of Rule 39.18. And then it has a second part that addresses the optional second tier provisions of Rule 39.18. So in that particular checklist, there, and in fact also in the checklist for designated attorneys, there's some new content based on guidance that came from Iowa Title Guarantee for attorneys who participate in the Title Guarantee program. If you're a participant, you might take a look at page 16 when you have a moment. Appendix B at page 18 is the annotated checklist for the attorney that you designate to perform first tier duties for you. And once again, there's some very good title guarantee content in there. Appendix E at page 26 sets out the forms that I mentioned just a moment ago that were developed by ITEC in preparation for the 2017 COE on this topic. And finally, I want to mention Appendix F, which is at page 50. That captures in its entirety the Bar Association's client file retention guide. And we did that because it's got some great guidance on preparing your client file retention policy and for your firm, because disposition of client files tends to be one of the bigger tasks that we encounter in administration of a practice. And there are some best practices described in that guide that I think are of value for any practitioner. So we're at slide 6 now. This one just breaks down the topics that we're going to use to review what we do in first tier planning. Now, my informal polling indicates that most practitioners in Iowa at this point are quite familiar with the basic concepts of Rule 39.18 and what the basic requirements are. So we're not going to dwell on a lot of this, but we do need to set it up for what's coming later in the hour. Okay, slide 7. Why do we do this? Why do we plan for a death or disability? Well, a couple big reasons. First, we've got rules that tell us that we need to. Comment 5 to the diligence rule mentions the duty to safeguard client interests in the event of our death or disability. And then here in Iowa, we added on to that with Iowa Court Rule 39.18, which, as you know, requires that we perform at least the first tier of planning. So those are the rules that we have to abide by if we're in private practice here in Iowa. But there are some personal and professional reasons why we should be doing this planning as well. Your professional liability insurance carrier may be very interested in whether you have this kind of a plan. And in fact, it could be a consideration in whether the insurer issues coverage for you. If you're temporarily disabled, preserving the viability of your practice pending resolution of the disability is likely to be in your economic interest. And finally, if you're permanently disabled or deceased, planning may assist in transfer of your practice to another attorney, may ease the burden of winding up or selling the practice on your surviving family members. So we have ethical obligations here, but we also have practical reasons why why planning for our death or disability is key for our practice. Okay, so now to the heart of this, the rule, which is on slide 8. 39.18 creates, as we've mentioned, 2 tiers of planning. The first tier is mandatory, and the second tier is optional. And the first tier, which most of you have done now for a few years, is the designation and authorization you complete as a part of your annual report to the Client Security Commission if you're in private practice in Iowa. Now, there's a key aspect of that I want to mention. You may remember that Chapter 39, in discussing the annual report and questionnaire that's filed with Client Security, requires that you update the information on that report form within 30 days anytime it changes. So that requirement also is going to apply to the designations that you make as a part of that report under Rule 39.18. And the Office of Professional Regulation has made it relatively easy for you to do that. If you look at your lawyer account page on the OPR website where you file your annual reports, there's a button entitled Update Designations. So during the year, if you need to, you can do that update online without having to have any other correspondence or contact with the office. Now, second tier. The second tier is basically an optional written plan that you create. In the optional plan, you can provide further guidance and authority regarding management of your firm and administrative tasks. And I decided to try and approach that from 2 different angles. First of all, what procedural benefits I can create in a second tier plan. And then secondly, what operational benefits I can try and achieve in that second tier plan. And we're gonna talk about those here in a few minutes. So before we do that, we do need to set up a couple definitions. The rule, the planning guide, and the ITEC forms all use some common terms. And we need to make sure we understand what those are. Designated attorney. That refers to the attorney or the lawyer you designate to administer your practice in the event of your death or disability. Planning attorney essentially refers to you, the attorney who is doing the planning and whose practice will be administered in the event of their death or disability. Now, Qualified Attorney Servicing Association. Instead of an individual Iowa attorney, you are permitted to designate a Qualified Attorney Servicing Association to do the duties as a designee under Rule 39.18. So what's that? It's a bar association that has at least some members admitted to practice in Iowa. Could be a company authorized to sell professional liability insurance here to Iowa attorneys, or can be an Iowa bank with trust powers issued by the Division of Banking. So you're authorized to designate one of those entities in your client security report. Now, I'm not aware of any significant entity activity as a servicing association at this point, except for the Iowa State Bar Association, which has made that servicing matter available to members of the bar. So I think that's it for that slide on definitions. Now, let's talk now about this first tier designation. So in your first year designation, you identified an active Iowa attorney, a law firm with at least one active Iowa attorney, or a qualified attorney servicing association. You also identified where your practice records are located, including the current client list, and you identified the custodian who can assist with access to those records in the event that it's necessary. Now, during the task force deliberations in, I think, 2016, there were some concerns about the ability of some practitioners to find someone to serve as their designated attorney. So just some thoughts about that. At least at first blush, it appears that your ability to locate a designated attorney will vary directly with the quality of the organization of your practice. A good client list, organized and minimized files, and good up-to-date trust account records are going to go a long way toward making another attorney comfortable accepting your designation. So now let's flip over and think about this from the vantage point of the designated attorney. If you're asked to serve as a designated attorney, a couple things for you to think about. And this basically goes to minimizing your risk. First, you can, by perhaps annually verifying the quality of your planning attorney's practice preparation, you can reduce some of your risk. Second, keep in mind that as a designated attorney, under the rule, you have an escape route. And it's called an application for appointment of a trustee under rules 34.17 and 34.18. So I would suggest that if you are considering taking on duties as a designated attorney, you might want to take a really good look at Appendix B of the guide, which is at page 18, to get a sense for what you're in for. Because I think we've got a pretty good annotated checklist for what you'll find yourself having to do. Okay, so what is your authority if you're the designated attorney? Well, basically the designated attorney or entity is expected to perform certain minimum tasks that are necessary to protect the interests of the planning attorney's clients. In this respect, it's much like a trusteeship. The focus is on protecting clients. So those listed tasks include what? Reviewing client files, notifying clients of the planning attorney's death or disability, administering the trust account, determining if other actions are necessary to protect client interests. What might those be? Returning files to clients, refunding unearned money that's in the trust account, making sure that the court is advised if there are any scheduled hearings in the short term. So Rule 39.18 provides you as a designated attorney some help, if you will. First of all, regarding the basis for commencing duties. You as a designated attorney can apply to the district chief judge for an order confirming that the planning attorney is in fact dead or disabled. Think about situations where there's some question about disability. Think about situations where the planning attorney has simply gone missing and can't be found. These may be some situations where the ability to put some definition on that question is going to be of value to you as the designated attorney. And of course, remember that you always have that ability to petition for appointment as a trustee under 34.17 or 34.18. Now, some thoughts here for you as a planning attorney. And this pertains to the first tier. The checklist at Appendix A of the guide provides some steps that we think should enhance the effectiveness of your designation when and if it has to be put into action. And I've tried to capture those, at least the major ones, on slide 12 and slide 13. Now, we're proceeding here on the basis that you already have made a designation and printed out and given the written signed designation form to your designated attorney or entity. Those are pretty much the basic two things that we start out with as something that need to be done. So let's talk for a minute about client files. You will want to avoid keeping original client documents in the client files. What are we talking about here? Abstracts, original copies of wills, those kinds of things. If you really think you have to keep those things, at least get them out of the client files and consolidate and index those in a way that you can administer those very quickly and feel confident there are none lurking in the client files. Better yet, just return them to the clients and don't keep them at all, except for copies. So another best practice with respect to client files is to periodically purge the old ones. Of course, you have to give notice to clients before you do that. And you want to make sure that, whatever retention period your client file retention policy provides has passed. And that may vary depending on who your malpractice carrier is and what kinds of matters you handle and the limitations of actions that pertain to your work on those kinds of matters. This is where the Bar Association's client file retention guide really comes into play. And I highly recommend that you take a good look and use the detailed guidance that's in that policy. So moving on, you might consider giving your designated attorney or entity a tour of your office. Introduce them to your staff if that hasn't already happened, and at least give them some familiarity with the office systems that you use and where to find the key information, client lists, pending matters, those kinds of things, trust account records. Okay. So on the flip side of that, it's really good for you to make sure your staff knows where the written agreement is, knows how to contact your designated attorney, and if you have one, your successor trust account signatory, and we're going to talk about that in a moment, why a successor trust account signatory may be necessary. And I think it's probably a good idea to sit down with your staff and talk about what assistance they should expect and that you would expect them to provide your designated attorney if that comes up. Now, if you practice without any regular staff, you're not going to be able to do some of that in terms of bringing your staff up to speed, but you definitely want to make sure your designated attorney and successor signatory know who the contacts are that will help them get into the office and your landlord, for example. And of course, that's information that's included in that report you file with the Client Security Commission. So do we have to tell the clients about our designation? Well, I think that arguably, because this is something that is required by court rules, you don't have an ethical obligation to tell your clients about it, and in particular, who it is. But as a matter of prudence, it's probably a good idea to disclose to your clients the existence of a designation and what that designation is about. And you'll find in the forms from from ITEC at Appendix E. I think it's at page 26. You'll find some forms that you can use to disclose the existence of your designation in your engagement letters and your retainer agreements. And I would suggest that that is a best practice. Finally, on slide 12, the best thing here you can do for you and for your designated attorney is have an orderly and disciplined practice. And if you look at page 15 of the guide, you'll see some information about that. So now we're on to slide 13, which captures what I think are some really crucial first-tier actions. The first one goes to your trust account. I think you should have a sit down with the proper people at your bank where your trust account is located to find out if your designation under Rule 39.18 and the provisions of that rule will be accepted as sufficient authority for your designated attorney to administer your trust account in the event that that is activated. You may find that some of the banks are a little cautious about that and would prefer that either that you have a separate successor signatory document produced that you produce under Rule 45.11, which authorizes that sort of thing, or the bank may even require that you use their form to make the designation. But it's best to find that out now and get it taken care of. So, and the benefit of that, of course, is that when something happens and we need to move money out of the trust account quickly to clients who need it to retain another lawyer or for whatever reason, or that maybe there's expenses that need to be paid, that we have somebody with authority in relatively short order who can take care of those trust account tasks. If the bank doesn't recognize either the designation form or the successor designation that you might otherwise have prepared, we have a delay, which probably will require going to the district court to clarify what your authority is as a designated attorney. So let's try and avoid that if we can. So I want to talk a little bit about what happens if you are a participant in the Iowa Title Guarantee program. Basically, once you make your designation, you want to let Title Guarantee know who you have designated. And Title Guarantee has told us that the way that the administration of the title guarantee files and the work associated with that will be handled is a function of whether your designated attorney also is a participant in the title guarantee program or is not a participant in the title guarantee program. If your designated attorney is a participant, title guarantee likely is going to ask them to go ahead and finish out the files, forward fees as they're appropriately owed title guarantee, and basically finish the work out as if they were in your shoes. If the designated attorney is not a title guarantee attorney, what they'll probably do is ask them to forward the fees that are being held for title guarantee to title guarantee along with the files, and they'll find somebody else who is a title guarantee attorney to finish out that work. So the procedures that title guarantee prefers are fairly specific and detailed. So if you're a title guarantee attorney, I recommend you take a good look at the checklist on page 16 and proceed accordingly. Now, regarding this next to last comment on slide 13, my successor at OPR, Trey Critelli, is the source of this one. Trey says that we should all create a file or a directory that's entitled "When I Die." And as we practice, and something occurs to us that would be of value to our designated attorney, put it in there so they've got access to that. Okay. Okay. We're going to move on now and talk a little bit about the second tier option. Of course, as we've talked about, and I think this is an important consideration for all of you, the first tier is focused on protecting client interests. A designation under the rule does not authorize your designated attorney all by itself to administer your practice generally. Like a trusteeship under rules 34.17 and 18, the actions of your designated attorney essentially will take down the client side of your practice, and it will leave the business and property aspects of your practice for someone else to sort out. But having watched numerous trusteeships administered, and the first tier is almost identical in terms of duties to what we do under a trusteeship, that's the end of the practice. So the optional second tier provisions of Rule 39.18 allow you to empower your designated attorney to more generally administer your practice. You can preserve some value or the practice itself, depending on the circumstances, and relieve your general legal representative of the burden of administering the practice. That's the overarching value of the second tier plan. So we're on slide 15 now. I mentioned a few minutes ago my mental division of the benefits of a second tier designation in terms of procedural benefits and operational benefits. Slide 15 goes to procedural benefits of a second tier supplemental plan. Now, the first really powerful thing you can do here is you can provide more guidance on when your designated attorney's powers become effective. Remember that Rule 39.18 simply says that the designation takes effect upon the death or disability of the planning attorney. In the supplemental plan, the circumstances under which the designation becomes effective can be more specifically described. For example, you can address certification by your physician. You can address yourself as the planning attorney asking, because of the circumstances, that the designation be activated. Or you can address that issue of disappearance, which may be a tough nut for the chief judge to consider if it comes up. So there is real benefit here in the second tier document of giving that some thought. When does it become effective, and addressing that? The other thing you can do, second thing that I think is really important, is you can designate an alternate designated attorney. Why might this be valuable? Well, suppose that your primary designated attorney has a conflict with respect to one or more of your clients. This gives them the opportunity to basically hand over whatever administration needs to be done for those clients to the alternate designated attorney, and avoid any further conflict situation with that. And of course, of interest to your designated attorney, you can address in your supplemental document how your designated attorney gets paid. And that's certainly always will be of interest to them. So on slide 16, I've attempted to capture some of the possible operational benefits of a supplemental plan. Of course, the first major benefit is expanding the power to generally administer the practice so that the value is captured for you or your survivors. Collecting fees you've already billed, fees that need to be billed, division of fees on work that only produces revenue at the end of the matter, like well, for example, a contingent fee case that some other lawyer is going to take to finish up. The ability to work on division of fees in that circumstance could be of tremendous value. And of course, other fairly normal things, paying expenses, paying staff to the extent that's necessary to finish up the practice, selling the practice. You can empower your designated attorney to transfer client matters to himself or herself, so long as the client consents, and other law firm administrative tasks. Now, another key distinction that you can address in the second tier agreement is what happens or what powers are available in the event of a temporary disability versus a permanent disability. If you're only temporarily disabled, you may not want that designated attorney empowered to go out and sell your practice. So your intent likely would be to come back. So you can differentiate between the situations when the powers take effect, and the rule itself does not do that. So there's some language in the ITEC form that actually gets to that, and so I recommend that you take a look at that. Okay. How do you implement the second tier? Well, you need a written agreement, and then you need some power of attorney language that makes the agreement durable under our law. Now, the way ITEC has chosen to approach that is to offer up a form for that second tier agreement, and then a second form for the power of attorney. And of course, they reference each other and work together. I think you should consider those forms a departure point and adapt them to your individual situation. So, slide 18. Some thoughts about the succession plan agreement. This basically, as we've talked about, supplements the designation you made on your client security report. So ITEC notes that their form will need some tailoring based on the specific facts and circumstances for each planning attorney, but I tried to capture some of the issues here on slide 18 that you'll need to consider when you do that adaptation. First of all, the triggering events. You want to look at paragraph 3 of the ITEC form and consider what they are suggesting in the way of triggering events, and whether you want to tailor that or whether you want to add some events to that. Sale of the practice. There is some language in the ITEC form about sale of the practice. I think you're going to want to look at that and expand a little bit on that. And conflicts of interest. We've talked a little bit about how conflicts of interest are handled. The paragraphs 8 and 9 in the ITEC form basically work like I've suggested, in that there is an alternate designated attorney who can pick up a particular client if there is a conflict. So you'll also want to think about what happens with real estate, perhaps that's associated with the practice, and how is that titled, and how is that going to pass in the event of your death in particular, and how does that impact the ability of the practice to continue to use it for a period? So those kinds of things. You also want to think about if you practice as an entity, there will be some authorizations by the entity that are required, and the ITEC people have given us some forms basically to address the issue of consent by the entity. Okay. Slide 19. Now we're at the durability requirement. Rule 39.18 requires that a designation under the rule include language that makes the powers durable. ITEC chose to make the durable power of attorney a separate form, and you'll find that at Appendix E of the guide. So the power of attorney form from ITEC and the succession plan agreement that they have designed do complement each other pretty nicely. For example, paragraph 2 of the power of attorney form contains the same draft triggering provisions as the succession plan agreement form. But still, whatever adaptations you make to one of those, you want to make sure you've got conformance with the other one so that the two documents work nicely together. Okay, slide 20, planning documents in your personal estate. You'll want to put a provision in your estate planning documents that deals with closure and sale of your practice upon your death. And the ITEC folks have given us some forms for this. They have forms, I think, both for your will and for your revocable trust. And basically, these forms direct your personal representative to engage your designated attorney to close or sell the practice in accordance with the succession plan agreement. So you've got someone that you've selected working the practice side of things, and your personal representative, who likely won't be an attorney, has that one off their plate, so to speak. So I mentioned consent actions. The ITEC form drafters here contemplated the possibility that an attorney might operate through an artificial entity, such as a personal corporation, personal limited liability company. So the entity in that situation also needs to authorize the actions of the designated attorney. And we preferably want to get that done before the designated attorney becomes incapacitated or passes away. So a simple way to take care of that is to execute a consent action. Basically, it's a written form providing the authority to the designated attorney. And I think the sample forms that have been provided here by ITEC actually let you do that without having a formal meeting to get that done. So I commend those forms to you. Okay, slide 22 captures, I think, what you will want to do or check now in your practice, with the overarching goal of keeping an organized and tidy practice. Now, slide 22, as was the case with some prior slides here, assumes that you already have given your designated attorney a signed copy of your designation form. And I'm not gonna go through this laundry list on this slide item by item. You can read as well as I can. So I just want to make a couple comments by exception. Trust account and billing records. It's really key that the trust account and billing records be up to date and balanced to the penny at any time. It's extraordinarily difficult to know what to do when we have a shortage or what appears to be a shortage in the trust account, and multiple clients who are owed money and not enough money in there to refund to every one of them what they're owed. We often get into a situation when that happens where we have to go to the district court and approach it almost like a receivership, where the claims get proven up and claims get satisfied at a proportionate amount of what's owed, and then the clients get an application to submit to the Client Security Trust Fund for reimbursement of the balance. That's a very messy, dirty process that clients don't like. So please keep your trust account balanced to the penny all the time, every day. Periodically purging paper files based on your client file retention program. Those of us who have practiced out in County Seat, Iowa, in firms that have been in existence for some time, know that it's fairly common to find 20, 30, 40, or 60 years worth of files in the basement. And we know it has value, because if we need to figure out what the basis is in a particular parcel of farmland that one of our clients came by decades ago, sometimes we can go down to the basement and figure that out. So I want you to understand that I'm not denying the value of past client files in some situations. And if you have a continuing law firm with lawyers who can look after those and extract value from them, more power to you. But if you're a sole practitioner and you probably want to seriously consider implementing that client file retention guide that minimizes the number of files that you keep. Best practice here probably will be to go digital, go electronic. So you simply don't have a lot of paper around. But in terms of my final thought here, in terms of what to do and check now, I recommend that you strongly consider a second tier agreement for all the reasons we've talked about. So slide 23, what to do now in your personal affairs, pretty straightforward. Need to have a will or a revocable trust or some dispositive document. Get the language in there that ITEC recommends, that complements your designation and your succession planning agreement. And the other thing I would recommend that you think about is cash flow. If we want to get the designated attorney, especially if they're a second tier designated attorney, if we want to get them paid, we have to think through what cash can be made available after your disability or death to take care of them. And one of the dangers that exists here is the possibility that the bulk of your property will pass to your heirs and leave the practice cash poor at a time when your designated attorney needs some liquidity to administer the practice. So thoughts about that. Business practice interruption insurance may provide some coverage for that. Disability insurance, insurance on your life, a separate policy perhaps, with beneficiary designations set up to fund the administration of your practice when the time comes. Those are some things I think to think about in your personal affairs right now. Okay. I think we're closing in on the last 10 minutes here. So I'm at my conclusion slide. I do recommend, though, and I don't have a slide for this, but on pages 18 through 22 of the guide, we have Appendix B which is the checklist for actions by the designated attorney. This is intended to catalog step by step for the designated attorney what they need to do if they are a first tier designee. And some things that I think that are important if you're a designated attorney. First of all, confirm the death or disability of the planning attorney. And as we've noted, you may have to go to the chief judge to get some kind of an order confirming if you're not comfortable. Immediately notify the Office of Professional Regulation. They can do some pretty helpful things for you. They know who the custodian is based on the client security report that was filed. They can provide open case listings for every county in Iowa, so you don't have to call around trying to get that. And they may have some other thoughts for you or advice given what the experience to that point suggests. Make sure that you've got proof of authority. If the planning attorney didn't give you a signed copy of the designation form, ask OPR for one when you call and talk with them, because they have the ability to print out an OPR generated form that evidences the designation of authority. Okay. Get access to the files and records and just take a look at what you've got. And use that as the basis for assessing the situation to determine if it looks to you like the first tier duties can be performed and you can be properly compensated. The level of preparation of the practice is a key factor, and you'll be able to deduce that pretty quickly. And the other factor is looking at what's the financial situation. Talk to the staff, talk to the spouse, for example. If you have to, that's the time to make the decision to proceed to a trustee appointment as opposed to trying to finish it out under the provisions of Rule 39.18. So those are some key aspects of the designated attorney duties. I commend the rest of Appendix B to you. I think it does a pretty nice job of capturing step by step what a designated attorney will want to do.